Hello, we are going into Chapter 8, Other Constitutional Basis for Personal Jurisdiction. We are going to look at the Daimler AG versus Bauman case, and then we will do a case brief of that case as well. So, general and personal jurisdiction, Daimler AG v. Bauman, distinguishing specific and general jurisdiction. The last chapter explained that a court can exercise specific jurisdiction over a defendant when a plaintiff's claim arises out of the defendant's deliberate in-state context and the exercise of jurisdiction is consistent with traditional notions of fair play and substantial justice. Under these circumstances, the claim is specific to the defendant's in-state context. In contrast, general jurisdiction allows courts to exercise personal jurisdiction over a defendant for claims having nothing to do with the defendant context in the forum. This general personal jurisdiction authority, however, comes with a catch. Before a court can exercise it, defendants must have much more extensive context in the forum state. Minimum context do not suffice. The distinction between an obvious question, how much more extensive do the context need to be before a court can exercise general jurisdiction? The Supreme Court has held that for corporate defendants, the context must be sufficiently extensive that the defendant is essentially at home in the forum state. Goodyear Dunlap Tires Operations S.A.V. Brown, 564 U.S. 915, 919, 2011. I have a problem with that word. Analogously, when the defendant is an individual, the requisite context exists wherever the individual is domiciled. So a corporation must be essentially at home in the foreign state, an individual must be domiciled. And that's from the Goodyear case. The chart below illustrates the basic distinction between specific and general jurisdiction. Requirements for establishing this form of jurisdiction, specific jurisdiction. Each of the claims must arise out of the defendant's deliberate context with the forum. That would be the minimum context. And the exercise of jurisdiction must otherwise be consistent with traditional notions of fair play and substantial justice. General jurisdiction, the defendant's contexts are sufficiently extensive that the defendant would be considered at home in the state. All right, so either you're at home in the state, so anything you do, or the claim must arise out of your deliberate context of the state. Claims over which the court's personal jurisdiction extends, only those claims arising out of the defendant's in-state context. So basically, you live in New Jersey, you have a car accident in New York, somebody wants to sue you there, but the thing is that do you have enough in-state context for them to have a specific jurisdiction for you? Any claim that the plaintiff has against the defendant for a general jurisdiction, okay, where the court has it. So you're at home in that state, so any claim can be filed against you there. For example, imagine that Damage Inc. is incorporated and has principal residence business in Ohio. Woohoo, my home state. Assume that Peter is injured in Indiana by a product that Damage designed, manufactured, and sold only in Indiana. Also assume that instead of suing in Indiana, Peter sues Damage in Ohio because Peter recently moved to that state. The Ohio court does not have specific jurisdiction over the claim because the claim does not arise out of anything that Damage did in Ohio. But there's an alternative to specific jurisdiction, general jurisdiction, because Damage Corporation headquarters and principal place of business are in Ohio. Damage is essentially at home there. The Ohio court can thus exercise personal jurisdiction over the claim that the plaintiff might have had against Damage, even a claim such as Peter's that arose entirely in Indiana. So they don't have specific jurisdiction because the claim arose out of something in Indiana, but they have general jurisdiction because they are at home there. Why is general jurisdiction fair? Personal jurisdiction exists to protect parties' constitutional rights to due process. So that's the purpose of personal jurisdiction. And the right is violated when a party is forced to litigate in an unfair forum. Indiana would be a fair forum in the above example because that is where the defendant's context gave rise to the plaintiff's injuries. But why is it also fair for Ohio court to exercise personal jurisdiction over Damage? The answer isn't entirely clear, even after the Daimler case below. One possible answer is that if a corporate defendant is effectively at home in the forum state, as Damage is in Ohio, based on the incorporation and principal place of business there, it is not much of a burden to defend the case there, even if the case arose elsewhere. Personal jurisdiction also appears to make sense under circumstances for a reason that trace back to Penoyer. Namely, a court has the authority to exercise jurisdiction over people and property within its territory. people and property in our territory, we have jurisdiction over. A corporation is at home in the state, is arguably within the state for jurisdictional purposes. Explaining that, although specific jurisdiction has been cut loose from Pennoyer sway, we have declined to stretch general jurisdiction beyond limits of traditionally recognized. The same can be said for individuals who are domiciled in the forum. General jurisdiction over corporations. The doctrine of general jurisdiction as applied to corporations is simply stated. General jurisdiction exists whenever a corporation is at home. The term at home, however, is self defining, as the following case makes clear. Reading Daimler AG Bauman. Daimler is one of the few modern United States Supreme Court cases to discuss general jurisdiction in any detail. As a result, the court has to refer back to two older cases and a more recent one to explain the concept. In one older case, Perkins v. Banquet Consolidated Mining, from 1952, the president of a company maintained an office in Ohio for which he conducted company related activities, such as keeping corporate files and holding directors' meetings. The court concluded that the company, which was based in the Philippines, had been carrying on in Ohio a continuous, systematic, but limited part of its general business, um, and that what we now call general jurisdiction was reasonable and just. In contrast, so in this one, they said that because they maintained an office in Ohio, conducted company related activities such as keeping corporate holdings director meetings, alrighty. General jurisdiction was reasonable and just, what we now call. In contrast, in Helicopteros Nationals v. Columbia versus Hall, the corporate defendant had a number of contacts in Texas, including sending its chief executive officer to Houston for a contract negotiation session, accepting into its New York bank account checks drawn at Houston Bank, purchasing helicopters, equipment, and training service from Texas company for substantial sums, and sending personnel to facilities in Fort Worth for training. Nevertheless, the court concluded that those contacts were not sufficiently continuous or systematic to warrant subjecting the company to general jurisdiction in Texas. In some, regular contacts were not enough. The contacts had to be more extensive. So, yeah, we had people go to training in Fort Worth. We cashed checks from Texas in our New York account. We sent our chief executive officer to Houston for contract negotiation, but they were kind of one-offs, right? So it wasn't extensive enough or continuous enough for them to have general jurisdiction. Finally, in Goodyear, Dunlap tire operations v. Brown, the Supreme Court considered whether a North Carolina court could exercise general jurisdiction over three foreign subsidiaries of Goodyear on the grounds that the subsidiaries manufactured tires and were sold in North Carolina. The suit did not arise out of those North Carolina sales, so the only basis for personal jurisdiction in North Carolina over the subsidiaries was general jurisdiction. The court concluded that it was unconstitutional to exercise general jurisdiction under these circumstances, reasoning that general jurisdiction is appropriate only when a corporation is at home in the foreign state and that the foreign subsidiaries were most certain not at home in North Carolina. Goodyear was the first case in which the Supreme Court emphasized the at home formulation. And many people wondered whether it reflected tightening of the general jurisdiction doctrine. Prior to Goodyear, most courts had assumed that general jurisdiction existed if the defendant merely had continuous and systematic contacts in the foreign state. That's what they said. The Goodyear court seemed to signal that continuous and systematic contacts just making sure I'm recording. The Goodyear court seemed to signal that continuous and systematic contacts were no longer sufficient for general jurisdiction and that general jurisdiction required a more extensive connection to the state. The company had to be effectively at home in the foreign state. Fortunately, the court decided another case, Daimler v. Bowman, not long after the Goodyear case, and it shed more light on the issue. Consider the following questions as you read Daimler. When is a company considered to be at home in a state for purposes of general jurisdiction? Is that at-home test narrower than the continuous and systematic contacts test? If so, how? What context did Daimler have in California? Why does the answer to this question turn on Daimler's relationship to one of its subsidiaries? Why were Daimler's contacts sufficient to subject it to general jurisdiction in California? Here's something about Ruth Bader Ginsburg, just explaining her history when she was nominated to the United Courts of Appeal. for the District of Columbia in 1980 by President Jimmy Carter and to the Supreme Court by Bill Clinton in 1993. Doubtless, as a veteran teacher and student of civil procedure, she has relished the chance to create civil procedure law in cases like Daimler below during her more than 20 years in the court. Okay, so now we know she's dead, but at the time this book was written, she was still alive. And that's because we're using the third edition because Professor Glannon said we could use the third edition and it was just as good. I have noticed some things that have been updated since then, but we are using the internet to supplement some of the cases. So, Daimler v. Bowman. This case concerns the authority of a court in the United States to entertain a claim brought by foreign plaintiffs against a foreign defendant based on events occurring entirely outside of the United States. The authority of a court in the United States to entertain a claim brought by foreign plaintiffs against foreign defendants based on events entirely out of the United States. All right, wow. So the defendant is foreign, the plaintiff is foreign, the defendant is foreign, and the events were not in the US. The litigation commenced in 2004 when 22 Argentinian residents filed a complaint in the United States District Court for the Northern District of California against Daimler Chrysler, a German public company headquartered in Stuttgart that manufactures Mercedes-Benz vehicles in Germany. The complaint alleged that during Argentinians The litigation commenced in 2004 when, okay, I already read that. Sorry. Had to take a mini break because it's getting louder on here. The complaint alleged that during Argentina's 1976 to 1983 Dirty War, Daimler's Argentinian subsidiary Mercedes-Benz Argentina collaborated with state security forces to kidnap, detain, torture, and kill certain MB Argentinian workers, among them plaintiffs or persons closely related to the plaintiffs. Damages for the alleged human rights violations were sought from Daimler under the laws of the United States, California, and Argentina. Jurisdiction over the lawsuit was predicated on the California contacts of Mercedes-Benz, a subsidiary of Daimler incorporated in Delaware with its principal place of business in New Jersey. MB USA distributes Daimler manufactured vehicles to independent dealerships throughout the United States, including California. The question presented is whether the Due Process Clause of the 14th Amendment precludes the district court from exercising jurisdiction over Daimler in the case, given the absence of any California connection to the atrocities perpetrators' victims described in the complaint. Wow, this is real deep. Plaintiffs invoke the court's general and all-purpose jurisdiction. California, they urge, is the place where Daimler may be sued on any and all claims against it wherever in the world the claims may arise. For example, as plaintiff counsel affirmed, under the proffered jurisdictional theory, if a Daimler manufactured vehicle overturned in Portland, injuring a Polish driver and a passenger, the injury parties could maintain a design defect suit in California. Exercises of personal jurisdiction so absorbent we hold are barred by due process constraints. Okay. On the assertion of adjudicatory authority. In Goodyear Dunlap Tires Operations S.A.V. Brown, we address the distinctions between general or all-purpose jurisdiction and specific or conduct-linked jurisdiction. As to the former, we held that a court may assert jurisdiction over a foreign corporation to hear any and all claims against it only when the corporation's affiliations with the state in which suit is brought are so constant and pervasive as to render essentially at home in the forum state. Okay. Instructed by Goodyear, we conclude Daimler is not at home in California and cannot be sued there for injuries plaintiffs attribute to MB Argentina's contact in Argentina. In 2004, plaintiffs responding here filed suit in the United States District Court of the Northern District of California alleging MB Argentina collaborated with Argentinian state security forces to kidnap, detain, torture, and kill plaintiffs and their relatives during the military dictatorship in place from 1976 through 1983, a period known as Argentina's Dirty War. Based on these allegations, plaintiff asserted claims under the Alien Torture Statute and the Torture Victim Protection Act. Note the following 1350, as well as claims for wrongful death, intentional infliction of emotional distress under the laws of California and Argentina. The incidents recounted in the complaint center on MB's Argentina's plant in Gonzales, Catan, Argentina. No part of MB Argentina's alleged collaboration with Argentinian authorities took place in California or anywhere else in the United States. Plaintiff's operative complaint names only one corporate defendant, Daimler, the petitioner here. Plaintiffs seek to hold Daimler vicariously liable for MB Argentina's alleged malfeasance. Daimler is a German that company that manufactures Mercedes-Benz vehicles in Germany and has its headquarters in Stuttgart. At times relevant to this case, MB Argentina was a subsidiary wholly owned by Daimler's predecessor in interest. Daimler moved to dismiss the action for want of personal jurisdiction. Opposing the motion, plaintiffs submitted declarations and exhibits purporting to demonstrate the presence of Daimler itself in California. Alternatively, plaintiffs maintained that jurisdiction over Daimler would be founded on California's context of Mb USA, a distinct corporate entity that, according to plaintiffs, should be treated as Daimler's agent for jurisdictional purposes. Mb USA, an indirect subsidiary of Daimler, is a Delaware limited liability corporation. Mb USA serves as Daimler's exclusive importer and distributor in the United States, purchasing Mercedes-Benz automobiles from Daimler in Germany, then importing those vehicles and ultimately distributing them to independent dealerships throughout the nation. Although Mb USA's personal place of business is in New Jersey, Mb USA has multiple California-based facilities, including a regional office in Costa Mesa, a vehicle preparation center in Carson, and a classic center in Irvine. According to the record developed below, Mb USA is the largest supplier of luxury vehicles to the California market. In particular, over 10% of its sales of new vehicles in the United States take place in California, and Mb USA's California sales account for 2.4% of Daimler's worldwide sales. The relationship between Daimler and Mb USA is delineated in the General Distributor Agreement, which sets forth requirements for Mb USA's distribution of Mercedes-Benz vehicles in the United States. That agreement establishes Mb USA is an independent contractor that buys, sells vehicles as an independent business for its own account. Appendix 179A, the agreement does not make Mb USA a general or special agent, partner, joint venture, or employee of Daimler Chrysler or any Daimler Group company. Mb USA has no authority to make binding obligations for or on behalf of Daimler Chrysler or any Daimler Chrysler Group. After allowing jurisdictional discovery on plaintiff's agency allegations, the district court granted Daimler a motion to dismiss. Daimler's own affiliations with California, the court first determined, were insufficient to support the exercise of all-purpose jurisdiction over the corporation. Next, the court declined to attribute Mb USA's California context to Daimler on an agency theory, concluding that the plaintiffs failed to determine that Mb USA acted as Daimler's agent. The Ninth Circuit Court affirmed the district court's judgment, addressing solely the question of agency. The Court of Appeals held that plaintiffs had not shown the existence of an agency relationship of the kind that might warrant attribution to Mb USA's context to Daimler. Judge Reinhardt dissented. In his view, the agency test was satisfied and considerations of reasonableness did not bar the exercise of jurisdiction. Granting plaintiff's position for rehearing, the panel withdrew its initial opinion and replaced it with one authored by Judge Reinhardt, which elaborated on reasoning he initially expressed dissent. Daimler petitioned for rehearing and rehearing en banc, urging that the exercise of personal jurisdiction over Daimler could not be reconciled with the court decision in Goodyear. Over the dissent of 8 judges, the Ninth Circuit Court denied Daimler's petition. We grant certiorari to decide whether, consistent with due process clause of the 14th Amendment, Daimler is amenable to suit in California courts for claims involving only foreign plaintiffs and conduct occurring entirely abroad. Let me see what this means. Rehearing en banc. What does it mean? A rehearing en banc is a rehearing heard by the chief judge of the circuit and 10 additional judges drawn by lot from the active judges of the court. All right, good to know. Okay, Federal courts ordinarily follow state law in determining the bounds of their jurisdiction over persons. See Federal Rule of Civil Procedure 4K1A. Service of process is effective to establish personal jurisdiction over the defendant who is subject to the jurisdiction of the court of general jurisdiction in the state where the district court is located. Under California's long arm statute, California state courts may exercise personal jurisdiction on any basis not inconsistent with the Constitution of this state or of the United States. California Civil Procedure Code and Section 410.10 West 2004, California's long arm statute allows the exercise of personal jurisdiction to the full extent permissible under the U.S. Constitution. We therefore inquire whether the Ninth Circuit Court's holding comports with the limits imposed by the federal due process. Okay, 3. In Pennoyer v. Neff, decided shortly after the enactment of the 14th Amendment, the court held that the tribunal's jurisdiction over person reaches no farther than the geographic bounds of the forum. The authority of every tribunal is necessarily restricted to the territorial limits of the state in which it's established. In time, however, that strict territorial approach yielded to a less rigid understanding spurred by changes in the technology of transportation, communication, and tremendous growth in interstate business activity. The canonical opinion in this area remains International Shoe, in which we held that a state may authorize its court to exercise personal jurisdiction over an out-of-state defendant if the defendant has certain minimum contacts with the state, such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. International Shoe's conception of fair play and substantial justice presaged the development of two categories of personal jurisdiction. The first category is represented by International Shoe itself, a case in which the in-state activities of the corporate defendant had not only been continuous and systematic, but also gave rise to the liability sued on. International Shoe recognized as well that the commission to some single or occasional acts of the corporate agent in the state may sometimes be enough to subject the corporation to jurisdiction in that state's tribunals with respect to suit relating to that in-state activity. Adjudicatory authority of this order in which the suit arises out of or relates to the defendant's contacts with the forum. International Shoe distinguished between, on the one hand, exercises of specific jurisdiction as just described, and on the other hand, situations where a foreign corporation's continuous corporate operations within a state are so substantial and of such a nature as to justify suit against it on causes of actions arising from dealings entirely distinct from those activities. As we have explained, a court may assert general jurisdiction over foreign sister state or foreign country corporations to hear any and all claims against them when their affiliations with the state are so continuous and systematic as to render them essentially at home in the foreign state. We have that in Goodyear, and then helicopter rules. Since International Shoe's specific jurisdiction has become the centerpiece in modern jurisdiction theory, while general jurisdiction has played a reduced role. Goodyear, quoting Twitchell, The Myth of Jurisdiction 101, Harvard Law Review 610, International Shoe momentous departure from Pennoyer's rigidity, territorial focus, we have noted, unleashed a rapid expansion of tribunals' ability to hear claims against out-of-state defendants when the episode in suit occurred in the forum or the defendant purposely availed itself to the forum. Our post-International Shoe opinions on general jurisdiction are, by comparison, are few. The court's 1952 decision in Perkins v. Benguet's Consol Mining Company remains the textbook case for general jurisdiction appropriately exercised over a foreign corporation that has not consented to suit in the forum. Goodyear. The defendant in Perkins, Benguet, was a company incorporated under law in the Philippines where it operated gold and silver mines. Okay. Benguet ceased his mining operations during the Japanese occupation of the Philippines in World War II. The president moved to Ohio, where he kept in office, maintained the company files, and oversaw the company's activities. Perkins v. Bingo at Consol Mining Company, the plaintiff, an Ohio resident, sued Bingo on a claim that neither arose in Ohio nor related to the corporation's activity in the state. We held that the Ohio courts could exercise general jurisdiction over Binguet without offending due process. That was so, we later noted, because Ohio was the corporation's principal, if temporary, place of business. The next case on point, Helicopteros, arose from a helicopter crash in Peru. 4 U.S. citizens perished in the accident. Their survivors and representative brought suit in Texas state court against the helicopter's owner and operator, Columbia Corporation. The company's contract with Texas were confined to sending its chief executive officer to Houston for contract negotiation sessions, accepting into its New York bank account checks drawn from a Houston bank, purchasing helicopters, equipment, and training services from a Texas-based helicopter company for substantial sums, and sending personnel to Texas for training. Notably, those contacts bore no apparent relationship to the accident that gave rise to the suit. We held that the company's Texas connections did not resemble the continuous and systematic general business contacts found to exist in Perkins. Mere purchases, even if occurring at regular intervals, we clarify, are not enough to warrant a state's assertion of personam jurisdiction over a non-resident corporation in a cause of action not related to those purchase transactions. Most recently, in Goodyear, we answered the question, are foreign subsidiaries of United States parent corporation amenable to suit in state court on claims unrelated to any activity of the subsidiaries in the foreign state? The case arose out of a bus accident outside Paris that killed 2 boys from North Carolina. The boys' parents brought a wrongful death suit in North Carolina state court alleging that the bus's tire was defectively manufactured. The complaint named the defendants not only the Goodyear Tire Rubber Company, Goodyear, an Ohio corporation, but also Goodyear's Turkish, French, and Luxembourgian subsidiaries. Those foreign subsidiaries which manufactured tires for sale in Europe, Asia, lacked any affiliation with North Carolina. A small percentage of tires manufactured by the foreign subsidiaries were distributed in North Carolina. However, on that ground, the North Carolina Court of Appeals held the subsidiaries amenable to the general jurisdiction of the California courts. We reserve, observing that the North Carolina court's analysis elided the essential difference between case-specific and all-purpose general jurisdiction. Although the placement of a product into the stream of commerce may bolster an affiliation germane to specific jurisdiction, we explain such contexts do not warrant a determination that based on those ties, the forum has general jurisdiction over the defendant. As international shoe itself teaches, a corporation's continuous activity of some sorts within a state is not enough to support the demand that the corporation be amenable to suits unrelated to that activity. Because Goodyear's foreign subsidiaries were in no sense at home in North Carolina, we held those subsidiaries cannot be required to submit the general jurisdiction of the state courts. As is evident from Perkins, Helicopteros, and Goodyear, general and specific jurisdiction have followed markedly different trajectories post-international suits. Specific jurisdiction has been cut loose from Penoyer sway, but we have declined to stretch general jurisdiction beyond the limits traditionally recognized. At this court has increasingly trained on the relationship among the defendant, the forum, and the litigation. Specific jurisdiction, general jurisdiction have come to occupy a less dominant place in the contemporary scheme. With this background, we turn directly to the question whether Daimler's affiliation with California are sufficient to subject it to the general all-purpose personal jurisdiction of the state courts. In the proceedings below, the parties agreed on or failed to contest certain points we now take as a given. Plaintiffs have never attempted to fit this case into the specific jurisdiction category, nor did plaintiffs challenge on appeal the district court's holding that Daimler's own contacts with California were by themselves too sporadic to justify the exercise of general jurisdiction. While plaintiffs ultimately persuaded the Ninth District Court to impute Mb Usa's California contacts with Daimler on an agency theory, at no point have they maintained that Mb Usa is an alter ego of Daimler. Daimler, on the other hand, failed to object below to plaintiffs' assertion that the California courts could exercise all-purpose jurisdiction over Mb Usa. We will assume then, for purposes of this decision only, that Mb Usa qualifies as its home in California. In sustaining the exercise of general jurisdiction over Daimler, the Ninth Court relied on the agency theory, determining that MBUSA acted as Daimler's agent for jurisdictional purposes, and then attributing MBUSA's California contacts to Daimler. The Ninth Circuit's agency analysis derived from circuit precedent, considering principally whether the subsidiary performs services that are sufficiently important to the foreign corporation that if it did not have a representative to perform, then the corporation's own officials will undertake to perform substantially similar services. The court has not yet addressed a foreign corporation. The court has not yet addressed whether a foreign corporation may be subjected to a court's general jurisdiction based on the facts of its in-state subsidiary. Daimler argues, and several court of appeals have held that a subsidiary's jurisdictional context can be imputed to its parent only when the former is so dominated by the latter as to be its alter ego. The Ninth District Court adopted a less rigorous test based on what is described as agency relationship. Agencies, we know, come in many sizes and shapes. One may be an agent for some business purposes and not others, so that the fact that one may be agent for one purpose does not make him or her an agent for every purpose. A subsidiary, for example, might be its parent agent for claims arising in place where the subsidiary operates, yet not its agent regarding claims arising elsewhere. The Court of Appeals did not avert to that prospect, but we need not pass judgment on invocation of an agency theory in the context of general jurisdiction, for in no event can the appeals court analysis be sustained. The Ninth Circuit's agency finding rested primarily on the observation that Mb USA services were important to Daimler, as gauged by Daimler's hypothetical readiness to perform those services itself if Mb USA did not exist. Formulated this way, the inquiry into the importance stacks the deck, for it will always yield a pro-jurisdiction answer. Anything a corporation does through an independent contractor, subsidiary, or distributor is presumably something that the corporation would do by other means if the independent contractor, subsidiary, or distributor did not exist. The Ninth Circuit's agency theory thus appears to subject foreign corporations to general jurisdiction whenever they have an in-state subsidiary or affiliate, an outcome that would sweep beyond even the sprawling view of general jurisdiction we rejected in Goodyear. Even if we were to assume that Mb USA is at home in California, and further to assume Mb USA contacts are imputable to Daimler, there would still be no basis to subject Daimler to general jurisdiction in California, for Daimler's slim contacts with the state hardly render it home there. Goodyear made clear that only a limited set of affiliations with the former state will render a defendant amenable to all-purpose jurisdiction there. For an individual, the paradigm forum for the exercise of personal jurisdiction is the individual's domicile. For a corporation, it is an equivalent place, one in which the corporation is fairly regarded as at home. With respect to a corporation, the place of incorporation and principal place of business are paradigm bases for general jurisdiction. Those affiliations have the virtue of being unique, that is, each ordinarily indicates only one place, as well as easily ascertainable. These bases afford plaintiffs recourse to at least one clear and certain forum in which a corporate defendant may be sued on any and all claims. Goodyear did not hold that a corporation may be subject to general jurisdiction only in a forum where it is incorporated or has its principal place of business. It simply typed those places, paradigm, all-purpose forums. Plaintiffs would have us look beyond the exemplar basis Goodyear identified and approve the exercise of general jurisdiction in every state in which a corporation engages in a substantial, continuous, and systematic course of business. Brief for respondent 1617 and NN78, that formulation we hold is unacceptably grasping. As noted, the words continuous and systematic were used in international shoe to describe instances in which the exercise of specific jurisdiction would be appropriate. Jurisdiction can be asserted where corporations and state activities are not only continuous and systematic, but also give rise to the liability suit on. Turning to all-purpose jurisdiction, in contrast, international suit speaks of instances in which the continuous corporate operations within a state are so substantial and of such a nature as to justly suit on causes of action arising from dealings entirely distinct from those activities. See also Twitchell, Why We Keep Doing Business with Doing Business Jurisdiction, 2001. International shoot is clearly not saying that dispute line jurisdiction exists whenever continuous and systematic contexts are found. Accordingly, the inquiry under Goodyear is not whether a foreign corporation's informed context can be said to be in some sense continuous and systematic. It is whether the corporation's affiliation with the state are so continuous and systematic as to render it essentially at home in the foreign state. So are you doing so much that this is your home? Here, neither Daimler nor Mb USA is incorporated in California, nor does either entity have its principal place of business there. If Daimler California's activities suffice to allow adjudication of the Argentinian rooted case in California, the same global reach will presumably be available in every other state in which Mb USA sales are sizable. Such exorbitant exercise of all-purpose jurisdiction would scarcely permit out-of-state defendants to structure their primary conduct with some minimum assurance as to where the conduct will and will not render them liable to sue. And that's from Burger King. It was therefore an error for the Ninth Circuit to conclude that Daimler, even with Mb USA's contacts attributed to it, was at home in California and hence subject to the suit there on claims by foreign plaintiffs having nothing to do with anything that occurred or had its principal impact in California. For the reasons stated, the judgment of the United States Court of Appeals for the Ninth Circuit is reversed. Notes and questions understanding Daimler and general jurisdiction over corporations. There's no place like home. When a corporation is at home for purposes of general jurisdiction, according to the court, a corporation is considered to be at home whenever its principal place of business, place of incorporation. All right. In footnote 19, the court explained that a corporation might also be at home in other jurisdictions where exceptional circumstances, and cites Perkins as such a case. In Perkins, the company's principal place of business was overseas in the Philippines, but because of World War II had devastating effect on the company's properties there, the company president directed the company's rehabilitation from an Ohio office. All right, given these exceptional circumstances, general jurisdiction existed over the company in Ohio, even though its principal place of business and state of incorporation were elsewhere. Prior to Daimler, many courts had assumed that general jurisdiction existed wherever a corporation had continuous and systematic contact. Is the at-home test narrower or broader than the continuous and systematic contact test? Why? The at-home test is narrower and more difficult to satisfy. A corporation may have continuous and systematic contacts in many states, but not be at home in any of them. Consider, for example, Walmart. It has continuous and systematic contacts in numerous states as a result of its substantial retail presence in those jurisdictions. But just because Walmart has dozens of stores in a particular state and thus may have continuous and systematic contacts there, does not mean that Walmart is at home in the sense of having its principal place of business or place of incorporation in those jurisdictions. Nor is there any basis to conclude that an exceptional circumstance exists that would warrant general jurisdiction in a state that happens to have a lot of Walmarts. The shift of approach probably means that large companies are now subject to general jurisdiction in fewer states than when the test was continuous and systematic context. Of course, a company like Walmart still may be subject to specific jurisdiction for claims that arise out of Walmart's conduct in a particular state, but general jurisdiction is not difficult to establish. So if you slip and fall in a Walmart in Ohio, you might have specific jurisdiction there. I was going to say Arkansas, but that's not good because Arkansas, you have general jurisdiction because Bentonville is where Walmart is headquartered. Why it matters. After Daimler, a company can be sued in a state where its contacts give rise to the claim specific jurisdiction or where its principal place of business or place of incorporation general jurisdiction. That seems to give a plaintiff a lot of options. So when will this change in general jurisdiction doctrine matter? One answer is that it will matter in cases like Daimler, where the defendant is a foreign company that has its principal place of business and place of incorporation abroad, and when the claims against the company arise out of conduct that occurred abroad. In that situation, there is no place within the United States where specific jurisdiction is possible. So if the plaintiff wants to sue in the United States, general jurisdiction is the only option. Another answer is that the new approach makes recovery for injuries more inconvenient when the plaintiff is injured in a state other than where the plaintiff lives. Imagine, for example, a citizen of Nevada taking a vacation in New York and getting hit by a Home Depot truck while visiting there. She returns home to Nevada and sues Home Depot in Nevada. Assume Home Depot has 50 stores in Nevada, but that its place of incorporation and principal place of business are elsewhere. It's actually in Atlanta. Before Daimler, this suit could be heard in Nevada, at least as a matter of personal jurisdiction. Home Depot most likely would have been found to have continuous and systematic contacts in Nevada as a result of its substantial retail presence there. It is probably not, however, at home in Nevada, so the plaintiff will have to litigate elsewhere. As a practical matter, this would likely be the outcome, even if personal jurisdiction is appropriate in Nevada, because a different concept called venue. This topic is discussed in detail in chapter 11 and 12. There are a number of recent examples of cases and rules that make litigating a case a bit more difficult for plaintiffs, and Daimler is arguably part of a larger trend. Keep an eye out for other examples of this development throughout the book. Daimler's context. The Daimler Mb Usa Distinction. Like many companies, Daimler consists of multiple corporate entities. The particular defendant contesting personal jurisdiction in this case is the parent company, Daimler AG. Daimler AG doesn't have a physical presence in California, so personal jurisdiction over the company turns on its relationship to a subsidiary, Mb USA. Mb USA is Daimler AG's exclusive U.S. importer and distributor. Mb USA purchases Mercedes-Benz cars from Daimler AG in Germany, imports the cars to the United States, and then distributes the vehicles to independent dealerships located throughout the country. Although Mb USA has multiple California facilities, Mb USA's place of incorporation is Delaware, and its principal place of business is New Jersey. One important doctrinal question is whether Mb USA's contacts in California could be attributable to Daimler. The court explained that there has been some disagreement over the extent to which a subsidiary's contact with the forum should be attributable to the parent corporation. For example, some courts have held that the imputation of contacts to an affiliated company is limited to situations where the corporate entities are not genuinely distinct from each other, such as when the typical corporate formalities between or among entities are not observed. Here's something about piercing the corporate veil. In contrast, in this case, the Ninth Circuit adopted a more liberal doctrine and concluded that a subsidiary's contacts in the forum are attributable to the parent if the parent and the subsidiary merely have a particular kind of agency relationship. The court declines to resolve this debate, but notes that this issue typically arises when there is an attempt to establish specific jurisdiction over a parent corporation as a result of a subsidiary's contacts in the forum state. The court then goes on to say that even if it were possible to establish general jurisdiction over a parent company as a result of the parent's relationship with a subsidiary in the forum state, there is no basis for doing so under the particular facts of the case. The court explains that even if we were to assume that Mb USA is at home in California, and further to assume Mb USA's contacts are imputable to Daimler, there would still be no basis to subject Daimler to general jurisdiction in California. For Daimler's slim contacts with the state hardly render it at home there. This passage can be confusing. If Mb USA's contacts are attributable to Daimler, and if Mb USA is at home in California, this passage can be confusing. If Mb USA's contacts are attributable to Daimler, and if Mb USA is at home in California, doesn't that mean that Daimler should be at home in California as well? The answer is that the focus is not on how many contacts the defendant has in the forum state, but on how many contacts the defendant has in the forum state relative to its contacts elsewhere. Mb USA contacts in California relative to its overall operations are quite high, but even if those contacts are attributed to Daimler, Daimler's contacts in California are slim by comparison to its worldwide contacts. In concurring opinion, Justice Sotomayor takes issue with that analysis. She contends that the court should have focused on the magnitude of the defendant's contacts in the forum, not on the relative magnitude of those contacts. Until today, our precedent had established a straightforward test for general jurisdiction. Does the defendant have continuous corporate operations within a state that are so substantial and of such a nature as to justify suit against it on causes of action arising from dealings entirely distinct from those activities? International Shoe Company v. Washington. In every case where we have applied this test, we have focused solely on the magnitude of the defendant's in-state contacts, not on the relative magnitude of those contacts in comparison to the defendant's contacts with other states. In sum, a majority of the court was willing to assume for the sake of argument that Mb USA was at home in California and that its contact should be attributed to Daimler. But the court nevertheless concluded that Daimler's connection to California relative to its contacts elsewhere in the world were still too slim to warrant general jurisdiction. Why not specific jurisdiction? Given the court was willing to assume that Daimler had contacts in California through Mb USA, why were those contacts insufficient for specific jurisdiction? Even if Daimler is considered to have contacts in California through a subsidiary, the plaintiff's claim did not arise out of those contacts, even under two commonly used tests. For example, none of Daimler's contacts in California were a but for cause of the plaintiff's injury, which occurred in South America. Moreover, none of Daimler contacts in California offer evidence concerning any elements of the plaintiff's claims. Because the arising out of requirement was not satisfied here, specific jurisdiction was not an option. A scholarly take on specific and general jurisdiction. Some scholars have suggested that general and specific jurisdiction should be thought of as merely 2 points on a sliding scale of personal jurisdiction. See William M. Richmond, essay, part 1, Cassette, Jurisdiction in Civil Cases, part 2, a sliding scale to supplement the distinction between general and specific jurisdiction. According to this view, courts should require more contacts as the relationship between the claim and the contact becomes attenuated. For example, if a claim is somewhat related to the context, but not related enough to confer specific jurisdiction, and the contacts are not sufficiently extensive to confer general jurisdiction, personal jurisdiction should nevertheless be permissible if the contacts are regular. The diagram below illustrates this idea. A single contact, regular contact sufficient to be at home jurisdiction, and then the relationship between the claim and the contact. There's no relationship between the claim and the contact, or they're strong. Personal jurisdiction exists in this triangle. So frequency of contacts in the forum state. The theory of personal jurisdiction makes more sense than a simple specific jurisdiction dichotomy. The problem, however, is that the sliding scale is more difficult to apply in individual cases and has sometimes led to less predictability than the current dichotomous approach. The choice between clear rules and more ambiguous but adaptable standards is a common dilemma in the law. On one hand, clear rule using specific or general jurisdiction, but not a sliding scale, is easier to apply. On the other hand, a bright line test sometimes produces results that are inconsistent with the policies that a particular doctrine was designed to achieve. For example, a standard like the sliding scale above might do a better job of ensuring that defendants are treated fairly than a simple specific jurisdiction dichotomy. But the standard is also more difficult to apply, has less predictable outcomes, and may increase costs by generating more litigation about personal jurisdiction. In general, the courts have erred on the side of adopting a rule-based approach to personal jurisdiction and typically have not referred to personal jurisdiction as a sliding scale. Nevertheless, by thinking of the doctrine as a sliding scale, it's easier to show how specific and personal jurisdiction relate to each other. Mid-question: personal jurisdiction and the national franchise. Consider the following question. Penelope buys a hot coffee at McDonald's in Florida, spills it on herself, causing third-degree burns. Upon returning to her home in Georgia, Penelope sues McDonald's and the Georgia State Court for negligence, alleging that the store sold excessively hot coffee and caused her to suffer damages. Assume that the Georgia long-arm statutes reach it as far as the constitutional laws, and that McDonald's is incorporated in Delaware, has its principal place of business in Illinois, and has 75 stores in Georgia. If McDonald's moves to dismiss the case on personal jurisdiction ground, the court will probably grant the motion, even under the most liberal definition of arising out of the case does not arise out of any contact that McDonald's had in Georgia. Deny the motion. The state court has the authority to hear all state law claims as a matter of subject matter jurisdiction. Grant the motion. McDonald's has its principal place of business, the place of incorporation outside of Georgia, so the Georgia court cannot exercise general jurisdiction in Georgia. As for the reasons set out in A, there is no specific jurisdiction. Deny the motion because the court would likely have general jurisdiction over the damages in Georgia. Is it C? Yeah, it's C. Great. Let's see. B is incorrect. Personal and subject matter jurisdiction are two distinct elements. Just because the court has subject matter jurisdiction does not mean it has personal jurisdiction. A is partially incorrect in that specific jurisdiction does not exist here, but specific jurisdiction is not the only way to establish personal jurisdiction. This leaves C and D. Until the court decided Daimler in early 2014, we believe that D was the proper answer to this question. Reason that McDonald's had continuous and systematic contacts in the farm state through its numerous restaurants there. Although Goodyear had made us more tentative about the answer because of the court's reference in the case to the at-home concept, we still thought that the answer was D. Now, however, Daimler makes C the best answer. Daimler makes it clear that at-home concept means that general jurisdiction typically exists over the corporation only when they are incorporated or have principal place of business. Here, that would be Illinois and Delaware. Although the court suggested that a corporation may, in exceptional circumstances, be at home in other states as well, such as the Perkins, where the Philippines company directed its business from Ohio due to the devastating effects of World War II. McDonald's does not seem to present such an exceptional case. After all, McDonald's has substantial connections with about every U.S. jurisdiction. Its contacts with Georgia do not seem unusual or exceptional given the nature of its operations. General jurisdiction over individuals domicile. In Daimler, the court affirmed Goodyear's holding that general jurisdiction exists over corporations where they are at home. Analogously, for an individual, the paradigm forum for the exercise of general jurisdiction is the individual's domicile. That is, individuals are subject to general jurisdiction wherever they are domiciled. General jurisdiction over a corporation and general jurisdiction over an individual are quite similar, but there is at least one important difference. A company may be subject to general jurisdiction in several different states simultaneously in its place of incorporation, its place of business, and perhaps in exceptional circumstances, a limited number of other jurisdictions as well. In contrast, individuals have only one domicile for purpose of personal jurisdiction. To summarize, if the lawsuit has nothing to do with the forum state and the defendant is an individual, the defendant can still be subject to general jurisdiction if the defendant is domiciled there. If the lawsuit has nothing to do with the forum state and the defendant is the company can still be subject to general jurisdiction if the company is at home there. The definition of domicile in this context is not necessarily the same as the definition of domicile in diversity jurisdiction purposes. Some courts, however, have held that the word has the same meaning in both contexts. All right, that's confusing. In rem and quasi in rem jurisdiction, Schaefer v. Heitner. All right. I think we're going to stop here and we will pick up with section 2 next time. Thank you so much for joining in for this episode of Legally Not Writ, Legally Reverend here. Thank you.